You know,
Okay, you got it.
can you guys hear me? People like Brian and Mel, they're a blessing. You know, I'm actually gonna start off today. I apologize if I'm slurring a little bit. I don't know what's going on. I'm constantly clenching my teeth at night, so I wake up with these huge headaches. I didn't even have my belt on. I feel so blessed because I could stuff this little pack in. I was afraid my pants were going to fall down. I forgot my belt. So, you know, it was so encouraging to do the Pledge of Allegiance. I know it sounds odd. I was at a sports event last night, and I looked around, and nobody put their hands on their heart. I mean, nobody put their hand on their heart, and it's kind of an odd thing because I remember when I grew up, that was mandatory, you know. And I remember I was speaking to a relative, and I was saying, when you grew up in China, it was, you know, 1930. It was a long time ago. I said, you know, how did you even decide to come to America? And he said, you know, there's this Catholic father, and you know, my relative grew up in a very pimpy. It's like a place that's just it's beyond farmland. It's undeveloped country within China. And here is this white Catholic father just communicating love and Americanism throughout China. And that's one of the reasons why he came over to the United States. I really want to encourage you, you know, it's like this thing we're kind of missing. And it's so encouraging to come here because I really see what we're really missing. It's not necessarily being Republican or Democrat. I think it's more of just being an American, and you really see that here. And I really hope that we can spread whatever it is. I mean, we really don't know what it is, and it's maybe a little bit hard to define, but I really hope that we can be able to spread that throughout Southern California because there are a lot of immigrants coming in, and they're coming in for many of the same reasons that my relatives came, which is they see something here in America that they don't have anywhere else, and they don't want to go back to. And for those of you that may be discouraged, that may say, well, you know what, you know, America, you know, the best days are behind it, I would beg you to think a little bit differently. I think 2013 is going to be better. And I really want to encourage you to see that and to spread not an idealistic view, but the truth, that America is the best place in the entire world. And with that, with the new immigrants that are coming in, for us to hold the integrity that our forefathers, our parents, and our uncles have done for 10, 20, 30, for some of you, 70, 80 years. And to really see that the immigrants that are coming in are really almost like your own children. And the way you treat them are the way that they're going to be treating other people. And, you know, I hope no matter what, 5, 10 years from now, I can be able to come back and everybody here is still putting their hand over their heart because we really are Americans. So let's begin with just, today I put the 5 reasons foreign investors get sued. It's partially, it's also issues that they have that I've typically seen. So let's begin. All right. Essentially, I started off the PowerPoint. I couldn't really finish it just because it was just really painful, so I stopped last night. But it's just typical lawsuits facing foreign investors and what we can do about it. So it's a very short PowerPoint, but at the same time, we'll kind of digress and I'll discuss specific issues that I see. So the importance of today's lecture, foreign investors are heavily dependent on advice of experts, such as yourself. Many real estate client relationships are actually fiduciary relationships. They're not necessarily agents or realtors merely doing real estate. And that's huge. For most people already, that's huge. But a fiduciary relationship is where they actually put their hopes and dreams and they actually trust you. And if you say A is B, then they don't believe that it's A. They actually believe that it's B. So that's the reason why there is importance today. Obviously, believe it or not, you guys are not the masters of everything. You know, the funny thing is they say that attorneys get asked more questions about everything, and I would beg to differ. I think real estate agents and brokers, you guys get asked everything, right? You sell a house, and then they get divorced, and they don't come to the attorney. They come to you, right? Their bathroom breaks as soon as they purchase the property. They don't call the plumber, right? They call you. So actually, it's, you know, you really, It's this odd thing, but because of the fact that they are unfamiliar with the laws of this country, but they are familiar with the fact of who you are and that you've sold them something or you've helped them transition to America, they think you're the master of everything. And obviously this is a new pool of clients, so it's important, I think, to advise them correctly if you decide that's important for you. Okay, so this is an odd lawsuit, but it happens a lot, and it's something called account stated. So the essential elements of an account stated are previous transactions between the parties establishing the relationship of a debtor and creditor, an agreement between the parties expressed or implied on the amount due from the debtor to the creditor, a promise by the debtor expressed or implied, to pay the amount due. What does that mean? So basically there's a relationship between two parties. It may not be a written contractual relationship. What ends up happening is they do business with each other. One person's a creditor, one person's a debtor. That's an account stated. All right, now, this is the twist that I think you need to advise your clients if you choose to advise them. The agreement of the parties necessary to establish an account stated need not be expressed and frequently is implied from the circumstances. In the usual situation, it comes about by the creditor rendering a statement of the account to the debtor. If the debtor fails to object to the statement within a reasonable time, the law implies his agreement that the amount is correct as rendered. So this is actually a very dangerous lawsuit. Why? Because what ends up happening is that two people, maybe two business people, usually, are in a transaction. One person sends an invoice to somebody else. The other person ignores it. Why? Many reasons, but one of the reasons are that they don't speak English, or in their country, maybe that's not a way to create a relationship, right? In an account stated lawsuit, if a person receives an invoice, or if a person receives a letter, and they don't object to it, the law presumes that there is created a debtor-creditor relationship. So, that is one of the reasons why attorneys have a tendency to write what are called confirming letters, right? Something occurs, I'm going to confirm it to you, and you need to object, or it's true. And I also recommend that to people in the real estate industry as well. If there's been a promise or something that's occurred, you write a confirming letter. In regard to monetary issues, when your client receives a letter or an invoice and they don't object to it or ignore it, they presume a creditor-debtor relationship and the amount is considered true. Now, the issue is, what is a reasonable, there should be a reasonable time period. If the debtor fails to object to the statement within a reasonable time, the law implies his agreement. Is there a definition of reasonable time? The answer is no. So it's all based on the circumstances. So for some people it could be a week, for some people it could be months, for some people it could be years. But in terms of the lawsuits I see, it's one person saying to another person, you owe me money, and the other person merely ignoring it. And that's how a contractual relationship is starting. Reason number 2, many of you know oral contracts are valid, because I get asked this all the time. Now, what's KC jury instruction? Did I spell that right? Okay, KC jury instruction 304. A KC jury instruction is, for those of you that go to court, civil court, there's what's called KC jury instructions. It's created by the California Judicial Council, and they make the law as simple as possible. For those of you that have served in criminal court, which I'm telling you, that's about as American as it can get. I think that's great. For those of you that have served in criminal court, it's called CalCrim, and they basically break the law down into elements. So here's the KC jury instruction. I took it from 304. Contracts may be written or oral. Contracts may be partly written and partly oral, and oral contracts are just as valid as written contracts, which is different than other countries, different from Europe and different from Asia, slightly different. Okay, so let's go to the next slide. I'm going to explain. However, what's important to you is that here in California, there are certain contracts that must be in writing. So when people come to you and they say, oh, well, this person promised me this or did that, you sold me a condo or a house, can you be able to help me? although I don't necessarily advise it, my recommendation is at least you are able to know what contracts must be in writing. They are. Certain contracts, if not in writing, are invalid. Terms that are not to be performed within 1 year. There are exceptions, but not very many. Promise to answer for the debt or default of another. 3, a lease longer than 1 year must be in writing or it's invalid. 4, an agreement with an agent, broker, or other to purchase or sell real estate or lease real estate for longer than 1 year. And 5, a contract to loan money greater than $100,000 that is not for personal, family, or household purchases. Okay, so this is an exception to what we just saw on the Casey jury instruction oral contracts. Certain contracts must be in writing or they are presumed never to have occurred. 3, there are contracts that must be in a foreign language. All right, there are contracts that must be in a foreign language, and that's under Civil Code 1632, and I'll go over them very, very quickly. A person in a trade or business who negotiates primarily in the Spanish, Chinese, Tagalog, Vietnamese, or Korean language in the course of entering into a contract with a consumer must give the consumer a written translation of the proposed contract in the language of the negotiations, or it's presumed invalid. The translation must be an accurate translation of every term and condition in the contract or agreement. This requirement of California law applies whether the negotiations are conducted orally or in writing. This section does not apply to contracts negotiated in any of the above languages if the consumer has an interpreter. Now, you have to be careful because many times they're going to say that you're their interpreter. Even if you're not their same nationality, even if you're not the same race, they're going to say that, so be careful. All right, so 1, credit sale contracts involving consumer goods and services of all kinds, including automobile purchases and leases. 2, virtually all loans or other extensions of credit for use primarily for personal, family, or household purposes, except loans secured by real property. 3, consumer loans secured by real property if arranged by a real estate loan broker or made by a personal finance company. 4, contract for the rental, lease, or sublease of apartments or other dwellings, including mobile homes, for a period longer than 1 month. So actually this is very important because people that are purchasing investment property, they are getting sued. Because what ends up happening, this is Adam Rollins, he's one of my mentors and it's his birthday. He's a super, super, super attorney. So, happy birthday. Contracts for the rental, lease, or sublease of apartments or other dwellings. Why is this important? Because many of your investors are purchasing real estate for the express purpose of leasing it to third parties, and they're getting sued. They're getting sued again because they're dealing primarily in Chinese or Spanish, and they're not providing their rental agreements over 1 month in the language that they negotiate with. So this is very important, and I particularly don't want you to be sued because they told you that they are using it for investment purposes, and you didn't tell them, hey, you need to have it in a language that they understand. All right, so this is important. And I'm not saying that what people do are reasonable or valid or logical, because in the United States you can sue anybody for anything and prove your case along the way. So it's a little bit different than Europe and Asia. All right. Reason number 4. Practicing without a license. And I say this at every lecture because at every lecture I get people that come up to me so stunned that this occurs. So, Business and Professions Code 143 shows no love for people that are unlicensed. And I always use this story because it's easy to remember. I remember it was about, I think 25, maybe 30 years ago, right? I was in junior high. This is 25 or 30 years ago I was in junior high. And I remember somebody one time sent me a message, and the message said 143. And I didn't know what that meant. And so I didn't respond. And the person was very upset. And how can you not respond? Don't you know 143 means I love you? And I said, oh, I don't know. What's my response? He said, it's supposed to be 1432. Now, the reason why I want you, it's easy to remember because Business and Professions Code 143 does not show love for people that are unlicensed. So in California, there's a lot of licensure requirements. For those of you here are licensed, attorneys are licensed, doctors are licensed. It's in the news right now, these birthing homes, I think many of them should be licensed as well, right? Because of the fact that they use midwives, in my opinion. So, here is the Business and Professions Code 143. No person engaged in any business or profession for which a license is required under this code, governing the department or any board, etc., I'm going to come down to here, may bring or maintain any action or recover in law or equity in any action in any court of the state for the collection of compensation for the performance of any act or contract for which a license is required without alleging and proving that he or she was duly licensed at all times during the performance of that act or contract, regardless of the merits of the cause of action brought by the person. This has been litigated so many times in the California Supreme Court. They go up to the Supremes, the California Supreme Court continues to say that we cannot support illegal relationships. So it would be like, I hire somebody to go shoot somebody else, a competitor, right? A competitor. I say, I don't like this person, I want them shot. That person says, oh my God, I can't do that. Was there a contract? Yes, there was a contract. There was a contract. However, it's an illegal contract. Therefore, it's an invalid contract, although there is a contract. That's what the California Supreme Court has also said. They have said that it does not matter about the merits. It does not matter about the merits, meaning that you can have, on the plaintiff's side, a great case. You've gone out and you have been hired to do all this work for somebody else. Unfortunately, you are unlicensed. The Supremes have said, I'm sorry, we cannot support an illegal contract. Now, some courts have not only said that this applies to plaintiffs, some courts have also applied this to defendants. How? By saying, may bring or maintain any action. Using this word is for the plaintiffs, or maintain any action. Some courts have said it applies to defendants as well. So if you are sued and you are unlicensed, for example, let's say a birthing house in Chino. Somebody, and it's very unfortunate because these people come in and they're lied to. They said, if you come to the United States and you pay us $5,000 a month or $10,000 a month, you're guaranteed U.S. citizenship. That's not the linchpin. That's not the linchpin. The linchpin is once they come, they're basically shuttled, and I've received calls where these women are pregnant and they have no more money. And essentially, these birthing houses are holding them up and saying, we don't care. If you don't pay us another $10,000, we're calling immigration right now, taking you away. You and your child will not have U.S. citizenship. Of course, a woman can't just wait till the child's an adult, but that's a separate story. Now, why is that important? It's important because what ends up happening is that if there is negligence, right? Let's say the woman has a child there. She's injured. She wants to sue the birthing house. If the birthing house is required to be licensed, for example, as a midwife, because there is midwife licensure, we would say under, some courts would say under this statute, may bring or maintain any action, they wouldn't be able to defend it. They would automatically be negligent. All right, I'm just kind of using an extreme example to try to hit home on the point. The next one is the Business and Professions Code 7031 related to the construction industry. Except as provided in subdivision E, no person engaged in the business or acting in the capacity of a contractor may bring or maintain any action or recover in law or equity in any action in any court of the state. There is a further linchpin of it that says here, it's in a separate section. I think it's maybe 7031B or C, I don't remember. What that means is that if you're in the construction industry and you are unlicensed, Business and Professions Code 7031 goes one step further. Someone can sue you back for all the money that they've given to you, and they can be able to get it back. So 143 basically says you can't sue, and if you are sued, you will lose. 7031 says any money, someone's paid you $1 million, you've built a beautiful home, no defects, nothing. That person can still sue you and get back $1 million. That's what 7031 says. And I'm sorry, maybe it's B or C. All right. Reason number 5, employment lawsuits. I see this a lot. Many people come, they open up small businesses or they open up big businesses, right? And what ends up happening is that they are sued. basic wage an hour, you have to pay minimum wage, you have to have workers' compensation for all of your employees. I understand that in Asia, everybody seems to be a 1099. Everybody seems to be just a 1099. A salaried employee is considered a 1099, but that's not the case here in California. The standard is that everybody's an employee. So if you don't give them a meal break every 5 hours, if you don't give them a rest break every 4 hours, if you don't give them overtime, if you make them work 7 days in a week, those are all potential lawsuits. And it's happening not just with small companies, but it's happening with big companies as well. We've had large litigation against very large businesses that violate California labor code on purpose because it allows them to make money. So if there's $10 million of violations and they're sued and there's a settlement of $6 million, there's a net profit of $4 million, right? So it happens in big businesses and small businesses as well. Discrimination. What ends up happening with discrimination, I do want to throw one thing in. Everybody knows that they shouldn't discriminate. But in California, not only must you not discriminate, but the code actually says that you must do a reasonable investigation. So let me give you an example what a typical reasonable investigation occurs when an immigrant that opens up a business gets sued. Someone says, my manager is treating me poorly. He does not like one nationality over another. I'll give you an easy example. I know a lot of you that are not Asian, you're very sensitive to the fact that there seems to be this mainland Chinese, Taiwanese, Hong Kong divide, right? There's these like, if you're from here, you don't talk to people from here, you don't talk to people from here. Well, there's discrimination within these subculture groups within the Chinese community. Well, let's say that that person goes up to the manager and says, hey, I feel discriminated against. The manager looks at everybody and says, you guys all speak the same language and really you do look alike, right? And so unfortunately, I don't see any discrimination. I really don't. That's actually a very reasonable and kind of logical way to look at things, right? But it happens with the Hispanic community as well. Latin American community, somebody from Guatemala is not going to like somebody from Honduras. It's not going to like someone from Mexico. Oh my God, Mexico, right? The language that they use, it's totally slang. It's not proper Spanish. That's also discrimination as well. I mean, you get all these different things that you hear. Well, typically, the immigrant owner is going to say, come on, guys, you can patch it up. Don't worry about it. Everything's fine. Talk it out. That's not a reasonable investigation. And that is a violation of the discrimination law. And that's the reason why so many plaintiffs are winning. Because they aren't able to prove actual discrimination. But they are able to prove a lack of reasonable investigation. Same with sexual harassment. Someone says to you, right, as an owner, they say, this person, every day he stares at me. You know, guys, you know what ends up happening, right? You try to control, right? But you end up staring, and you make people feel really uncomfortable, right? It happens, right? You see it in a lot of businesses. Well, the female goes to the manager, the owner says, look, I'm very uncomfortable. I've tried, I don't wear makeup anymore, I don't wear skirts anymore, I literally try to look like Mother Teresa, and this guy's staring at me, right? What does the owner says? Looks at the person and says, yeah, you do look like Mother Teresa, I never look at you, right? Don't worry about it, don't worry about it. You know, everything's fine. Come on, he's always joking around, you know him. That's not a reasonable investigation. And that's the reason why many of the discrimination and the sexual harassment lawsuits win. Not for lack of, not necessarily for overwhelming evidence, but for a lack of reasonable investigation. What I've always recommended to business owners is you suspend the offending person until you actually do a reasonable investigation. You can always hire a law firm very inexpensively to do a third-party consult to meet both parties and make a determination. It would cost you 2 hours, $500. And then if there is a lawsuit, at least that part of the lawsuit, you would be able to show that there was a reasonable investigation. Versus being sued, the average lawsuits that I see for sexual harassment are between $100,000 and $150,000 settlement. For discrimination, it's usually between $50,000 to $150,000 in settlements. And I talk about settlements because only 3% of cases go to trial in California. All right. One of the bonuses that I want to talk about, I know it seems kind of unclear, but I've given the PowerPoint over to Brian, so he'll email it out to everybody. Going down, you go to Supreme Court, Appellate Court, Superior Court, there's administrative courts, other courts, and then there are these specialty courts down in the Superior Court. I wanted to talk about these two, which is limited jurisdiction and small claims. There are ways There are ways to have your cake and eat it too if your damages are not that much. Limited jurisdiction are for lawsuits under $25,000. $25,000. The case is actually very small, meaning that normally cases are very expensive because of the fact that discovery is overwhelming. I can ask you anything about yourself practically, and you have to respond. You can ask me everything about myself, the plaintiff, and I need to respond. Back and forth, back and forth. In limited jurisdiction, under $25,000 in damages, you are limited to only 35 questions and 1 deposition, and that's it. 35 questions and 1 deposition, and that's it. So if you ask them 34 questions regarding producing documents and 1 question whether they're a fault or not, that's it, no more, you're done. And 1 deposition, and that's it. Small claims, it's very good for you to offer to people. Small claims is under it's up to $10,000. They've upped it, I think, within the last couple years. There are a couple things that I think are great. First, attorneys are not allowed in the small claims process. I think that's very good because you end up arguing facts. You know, at the end of the day, most people don't care about the law as much as what's fair. And so in small claims, you can be able to bring your case, a factual case, to the judge. And if the other side's represented, you can tell the judge, Your Honor, I'd like that attorney removed or to sit in the audience. And the judge will do that. 2, you can be able to sue corporations in small claims as well. If it's up to $10,000, we get a lot of calls, right? $8,000, $3,000, somebody owes you money, etc. I think this is a very good place for you to go, which is small claims. And I've given a link to the small claims. I believe that is the California Attorney General, and if you just click on it, it'll take you there, or just copy and paste it, and it'll bring you to that link. Okay? How much time do we have?
Just about.
Oh, okay. All right.
It's over.
I wanted to also say, one last thing, since we're talking about immigrants. I remember when I first opened up my practice, it was a while back, it was 7, 8 years ago, and I remember I had no business, right? And my family's been in real estate for a long time, they wouldn't even give me business. and what ended up happening is, I remember, my mom, she's very sweet. My father's passed, so I do take care of my mom. She's a really, really wonderful, wonderful woman, and she's getting a little bit older, and I remember at that time, she couldn't see well, and she broke glass into my food. And I remember because I didn't have any money, it was really tough. And so the debate internally was, do I spend the $6 or $7 for fast food, or do I eat the food? And I remember I just said, you know what, I'm eating the food. So I remember eating the food, and the glass is crunching in my mouth, and I'm thinking, this is not normal, this is really not good. And the reason why I share that with you is because recently, we litigated an immigrant abuse case. And I remember this guy, he didn't speak any English whatsoever. And as we were litigating it, because we take 20% of our business, apart from real estate and business litigation, we take on immigrant abuse cases, because I believe that, again, if we litigate against the immigrant community and they become compliant, everybody becomes more American. That's the philosophy we have at the firm. Some people may disagree. Well, what ended up happening was that there was a settlement. And I could tell that depending on what I said to him, because he didn't speak English, that we would get another, I think it was $1,500 or $2,000, but it belonged to him. And frankly, I struggled. I struggled because of the fact that here I am, this person didn't speak any English, we litigated the case over 1.5 years, and we were able to get him a lot of money. And suddenly all the feelings hit me, I remember crunching glass and doing these things, and what's this extra $1,500, $2,000? Well, the decision ultimately, obviously, was that I wasn't going to lie. And so we have communicated to him, and we've told him, he was very happy, he didn't know any difference. But the reason why I wanted to share that with you is because of the fact that it's important when you work with immigrants to realize that you are in a position that is much different than anybody else. They really, 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 really trust you. And you are the ones that build the house. Attorneys are the ones that seem to tear it down. It's unfortunate. That's our job, right? I mean, we're hired fighters, right? You don't want to fight, you hire an attorney, he goes and fights for you and slugs away as hard as he can. But I do want to say this. You are in a position that I have never seen that I wish that I could be, which is you build people's lives up. And the words that you say are very powerful. And I really want to encourage you. I know a lot of you for the last 2 years have had it really tough. I know. I mean, I've talked to some of you, and some of you are in a position that you've never thought would happen. And I do want to say this, that although you may struggle, and although you may not feel good by being honest and telling the truth, I can be able to say this. At the end of the day, you are doing what is right. And you are doing what the Catholic Father is doing when he met my relative in China during the 1930s. All the struggles that he was doing, I mean, come on, he's struggling. This is China in 1930. He is struggling. But yet he is saying to himself that he is not going to abuse the position that he is in. He's going to communicate not just love, but sincerity and honesty. And I'm encouraging all of us, encouraging myself, not to do not just what's right, but to really take the high road, because I think that there's so many people during the economic struggle that will do anything that they can to make that extra $1,000 or $2,000. And I can guarantee you that if you take the better road, that you will not only love yourself, but that you will be able to say, this is the America that we want, and this is the America that I will communicate. So thank you very much.